The overarching question of the two cases that I handled was, does academic freedom allow teachers to disregard a text or curriculum? The first case that I talked about, Kirkland versus Northside Independent School District, is a case that comes out of the year 1989. Timothy Kirkland was a high school teacher who taught history and social studies for the Northside Independent School District. Kirkland's teaching contract was not renewed for the upcoming year. When Northside Independent School District decided not to renew Kirkland's contract, this was during his probationary period as a teacher, meaning that he was in the first 5 years of teaching at the same school district. Kirkland thought that the reason that the school district was not continuing his contract with them was because they were trying to censor the reading list that he created for a history class. The reading list that Kirkland had prepared for the class was merely supplemental and different from the one that the school district originally supplied him with that matched the curriculum that he was supposed to be teaching. The fact that Kirkland created a reading list for this class was completely fine. What he failed to do, though, was adhere to the guidelines that Northside had subjected its teachers to if they had to create a supplemental reading list, which was they needed to have it approved by administrators, and it also needed to be something that included books that added to what the curriculum was saying. Kirkland, however, did not seek approval for the reading list he had created, meaning Northside District was never able to approve it. Something important to note, however, is that all the books on Kirkland's list were already a part of curriculum for different classes in the Northside Independent School District. Rather than the censorship of Kirkland's reading list, Northside Independent School District had their own reasons for wanting to not continue their contract with Timothy Kirkland. Northside claimed that Kirkland failed to administer good supervision to special discipline classes, create healthy interactions with teachers, students, and his students' parents, and that he consistently received subpar teaching evaluations. Initially, Kirkland's story was favored by the courts, and he was rewarded $50,000 for the troubles that he had been through, and Northside School District was required to renew his contract with them. However, Northside appealed to higher courts, and the ruling was overturned. The higher court concluded that Kirkland's First Amendment rights, freedom of speech, were not being prohibited and not being infringed upon. The second case I covered was Pelosa versus Capistrano Unified School District, and this is a case from 1992. John Pelosa was a high school biology teacher in the Capistrano Unified School District. Pelosa started seeking the aid of the law because he believed that Capistrano Unified School District was forcing him to teach evolution as a fact or religious belief, which he strongly disagreed with because of his own personal religious beliefs. Pelosa believed that the school district was infringing on his rights of free speech by requiring him to teach evolution as a part of his biology curriculum. However, Pelosa was often inconsistent with what his claims actually were. Sometimes he said Capistrano School District was forcing him to teach evolution as a true fact. And other times he said the school district was forcing him to teach evolution as a valid scientific theory. In general, though, he was most upset that Capistrano School District would not allow him to teach creationism as an alternative theory to evolution. Among the other claims that Pelosa made, he also said that the school district had strictly forbidden him to discuss religious matters in any capacity on the school district properties, and that Capistrano was also trying to destroy his community images and his career as a teacher. To fight these claims, the school district argued against Pelosa, saying that he had been consistently ignoring the given and approved curriculum, and that he was using his platform as a respected adult in the school to teach students about his own religious beliefs. The curriculum in question was, in fact, just in concordance with what the state of California required its teachers to teach in biology. The courts realized that Pelosa's argument was not always consistent with itself, and that his idea of what evolution was compared to what the scientific community accepts it as was not always the same. Ultimately, the court sided with Capistrano Unified School District and awarded them around $30,000 of money in attorney fees and court fees.